Hello, country people. Sometime around 2016, I boarded a Peace Mass Transit Hiace bus from Aba heading for the north. After quarreling with the guys loading the vehicle, I asked for a refund of my money. Could you imagine that? From my seat at the back, I could barely see the driver or anything forward. I couldn't move my body at all because of the excess luggage in the bus. So rather than give me back my money, they threatened to beat me up. I have had the same problem with Telemass Transit and some others. And you know what happened? Arboros appeared and they were ready to deal with me. And on each occasion, I kept my cool and continued the journey because I can't fight. You know, these guys have touts. And I don't think this is right. I'm supposed to have a refund of my money if I'm no longer comfortable with the journey due to some circumstances that were so evident. Anyway, I was told that that was how they operate, and if I'm not okay with their mode of operation, I should always avoid those transport companies that carry excessive luggage. You know, this is the same attitude that some also display in most markets. You return a bad or maybe substandard product or something that did not work, that was sold to you, and they refuse to refund you your money. At most you will get is they give you another product, which you are not also sure that it will work. Now here is a similar situation, though this does not have to do with luggage. This policy of no refund money after payment is illegal in Nigeria. A court has ruled on that. And the court ordered Peace Mass Transit to pay 500,000 naira in damages for refusal to refund a lawyer for abandoned journey. The incident that led to the suit occurred on the 10th of February 2021 when a plaintiff purchased a ticket from Obolafo branch of Peace Mass Transit Limited to convey him to Enugu. Following a 2 hours delay occasioned by the absence of passengers, the plaintiff returned to the ticketing office and asked for a refund of his money he paid as transport fare. Now let me read the detail of how things went, what transpired and led to him getting a judgment and paid him the fine of 500,000 naira. They were fined. A high court in Enugu State has set aside the no-refund policy mostly used by service providers to prevent returning payments made to them by their clients, users. The court, through Honorable Justice C.O. Aja, declared the no-refund policy as illegal, null, and void in the light of provisions of Section 120, 104, 129, subsection 1A and B, 3 of the Federal Competition and Consumer Protection Act 2018. The judgment, which was delivered in suit number E/514/2021, was instituted by the plaintiff Patrick C. Chukwuma after the defendant refused to refund his bus fare after failing to convey him to his destination. You know this case of the bus must get filled before they leave. The incident led to the suit occurred on the 10th of February, like we said, 2021, when the plaintiff purchased a ticket from Obolafo branch of Peace Mass Transit Limited to convey him to Enugu. And following a 2 hours delay occasioned by the absence of passengers, the plaintiff returned to the ticketing office and asked for a refund of the 500 he paid as the transport fare. Staff of the defendant, however, refused to refund the money, insisting that their company policy was that money paid for transport fare cannot be returned to the passenger, and citing the statement written on their ticket to that effect as a conclusive proof of their position. When the plaintiff tried to explain to them that their policy was unlawful, as the law mandates them to refund fares for services that have not been provided, they retorted in a rude manner. As usual, they might hire touts, prompting the land council, they never knew he was a lawyer, to leave their park and seek other ways, alternative means of traveling back to Enugu. A letter written by the lawyer to Peace Mass Transit demanding an apology and refund was neglected, prompting the lawyer's law firm to institute the action. In the action, the plaintiff asked the court to determine a sole question, which was whether the defendant's policy of no refund of money after payment is in violation of Section 120 of the Federal Competition and Consumer Protection Act 2018, especially when the contractual obligation to convey the plaintiff to his preferred location was terminated. The plaintiff, represented by his lawyers led by Barrister Tochukwu Odo, amongst other grounds, argued that the Federal Competition and Consumer Protection Act 2018 is the primary law on questions of consumer transaction in Nigeria, and that by virtue of Section 120 of the law, the consumer has a right to cancel any advance booking, reservation, or order for any goods or services, subject only to the deduction of a reasonable charge by the service provider. I hope other transporters and businesses that are related are listening. The defendant, through their counsel, Barrister Titus Odo, raised technical arguments on the jurisdiction of the court and mode of the commencement of the suit. Honorable Justice C.O. Aja of the High Court of Justice, in his judgment delivered on 7th April 2022, promptly dismissed the objections of the defendant and upheld the argument of the plaintiff. The Honorable Judge, after a thorough analysis of the provisions of the Federal Competition and Consumer Protection Act 2018 vis-a-vis the conduct of the parties in the case, decided that indeed the policy of no refund of money after payment is illegal, null and void in light of provisions of sections 120, 104, 129 subsection 1A and B, 3 of the Federal Competition and Consumer Protection Act 2018. And the court thereafter made a declaration that the refusal of defendant to refund the plaintiff the money paid for the transportation fee from Obolafo to Enugu on the 10th day of February 2021 is unlawful. And the court further ordered the defendant to pay the sum of 500,000 naira as damages to the plaintiff. And this case puts service provider on notice that more Nigerians are now alive to their rights as citizens and will not hesitate to enforce same should the need arise. It also put an end to the menace of service providers who collect money from consumers and refuse to refund same money when they don't offer the service for which the money was collected in the first place. So again, if you're collecting money from a passenger, I'm talking about these transporters, especially, they are the main problem. If you're collecting money from a passenger, maybe let me talk about Peace Mass Transit that is known for carrying luggage. Let the passenger understand this is a bus that is, that you people are known for luggage. And in a case whereby the passenger says, there are so many luggage in this motor, I cannot continue this journey, he has the right to be given back its money. You have seen the judgment that was passed in this case. Anyway, viewers, I would like you to react to the video we just shared. What do you think? Add your comment on the comment section. I'm Azoka OJ. Bye for now.